Hey everybody, it's Mike Kennedy. Welcome back to my garage for another show on legal ethics. This one's going to be about 12 to 15 minutes long. How do I know? Because I've had so many flubbed takes already that I know how long it's going to take. Couple things. First, today, not using the whiteboard that I used in the last video. Today you're going to want to follow along on my blog. You're going to want to go here, vtbarcouncil.wordpress.com. At the top, you're going to see a tab that says the PR Madness Bracket. That's what we're looking at today. Now, once you get to that tab, click on the link for full bracket. I'm going to go through it. First, I'm going to tell you what it is. I'm going to digress and say it's really crowded in here today compared to the last video I did, because here's why it's crowded. That noise, that's the hood of my car. My car is parked right there. Well, why is it parked right there, Mike? Good question. It's parked right there because when I filmed that video in here last week, right down here, which you probably can't see, were my summer tires. Right now, my summer tires are on that car because the day after the video, I brought the car in to have the tires switched over. Now, down here, the winter tires. Well, what's that got to do with why your car's in your garage, Mike? Outside today, snowstorm. Snowstorm. Took me 40 minutes to get home, a trip that usually takes 15 or 20, because I have my summer tires on. Was going to leave the car in the driveway. Didn't want it to be covered in snow and have to brush it off in the morning, although it probably would melt. But then I got nervous in the driveway because I actually paused till I opened the garage door, and when the door got open, started to go again, couldn't go anywhere. Got nervous, put the car inside, didn't want to deal with it on the slope tomorrow. Anyway, so the PR Madness Bracket is based on college basketball. This is usually my favorite sports time of the year. The college basketball tournament's going on. Not going on this year because of the coronavirus pandemic. Speaking of which, I hope everybody's doing okay, safe, healthy, being kind, being positive, supporting others. So what I did as a diversion for myself and maybe for you, and as a way to add some educational value to that diversion, specifically education on professional responsibility and legal ethics, I created the PR Madness Bracket. PR for professional responsibility. It's set up just like the regular brackets that you fill out, that I fill out and always get horribly wrong every year. And instead of teams, though, it's concepts that come up in the inquiries I receive, the questions I get at CLEs, and that are raised in the complaints that are filed against lawyers. You can vote. It's one matchup at a time. We're going to go through each one just in one of the quadrants in this video. And you can vote. You can pick however you want. Is it a rule you like, a rule you don't like? Vote for the one you like. Or maybe vote for the one you don't like, because then maybe that'll make Mike do a CLE about it. Or, you know what, I got that rule down, I'm going to vote for that one. Or Professor Bernardi, Professional Responsibility blog, great blog on legal ethics, he emailed me. He's going to make his votes based on which rule is more important, more necessary. Anyway, whatever your criteria are, go for it. Okay, so in real life, once the brackets come out, the talking heads go on TV and radio and do an instant analysis of each of the quadrants. Which teams they think have a chance to succeed, which teams they think are overrated, which teams are sleepers, why each team might win, why it might lose. So that's what I'm going to do right now. Starting with the top left bracket there, duties to non-clients. The top overall seed in the tournament and in this quadrant, candor to a court. Arguably the most important rule, trumps all the other rules. I think you can make that argument. I mentioned that in my video, Sailing the 7 Seas of Legal Ethics. Rule 3.3, you should understand your duties of candor. It goes beyond just you have to be honest. Remember, if you know that a client has testified falsely or submitted false evidence to the court, you have to remonstrate with the client. Look at the comment. There are several steps from there that may include notifying the court. Against the 16 seed, frivolous claims, Rule 3.1. Mike, why is that a 16 seed? Those are the teams that barely make it into the tournament. In real life, that's an important rule. I agree. Don't file frivolous claims. However, I said the participants are based on the inquiries I get, the questions I get, the complaints we receive. Get very few about Rule 3.1 and frivolous claims. I think That's because the trial courts deal with those issues in the context of Rule 11 motions. So whoever gets the most votes in this matchup will advance to there, just like a regular bracket, and face off against the winner of this one, the 8 versus 9 matchup. The 8 seed, rule 4.2, communicating with a represented person. Remember, it's represented person, doesn't have to be a party in a matter. It doesn't have to be like a case that's filed in court. Also remember, if the represented person initiates the communication with you, doesn't matter, don't respond, cut it off. You got to go through the lawyer. Only time you can talk to a represented person is when you're not representing somebody else in the matter and it's a represented person who is calling you for a second opinion on advice they're receiving from their lawyer. That's going against the 9 seed, rule 4.5, the rule that prohibits lawyers from presenting, participating in presenting, or threatening to present criminal charges to get an advantage in a civil matter. A lot of states have dropped the rule. They prosecute it under other rules, the conduct that the rule is supposed to get at. So has the ABA. Still on the books here in Vermont, I think read literally, strictly, prohibits conduct that probably it was not meant to prohibit. It rises up to a 9 seed, not because it happens a lot in Vermont, although I do get calls on it, but because I get calls on it, something that I think violates the rule, even though it's not, doesn't say it in the rule, and that is threatening to file a disciplinary complaint against a lawyer in order to get an advantage in the matter in which the lawyer is on the other side from you and your client. I think that's a big no-no. Some states have held it violates this rule. Number 5 seed in this bracket, inadvertent receipt, rule 4.4b. You're representing a client, you get something, it could be a letter, a voicemail, an email, that you're pretty sure, or you know, wasn't meant for you. What are your duties? In Vermont, the ethical duty is to notify the sender. That's it. The comment to rule 4.4 says what you do from there is left to your professional discretion. Remember, however, there may be other duties imposed upon you by, for instance, the rules of civil procedure. You receive something that's arguably privileged. The rules of civil procedure set out how you can deal with that, if at all. Only ethical duty, notify the sender. Against this 12 seed, dealing with the unrepresented person, that's rule 4.3. You've got a client. Either the other side is unrepresented or you're talking to a witness who is not represented. What are your duties? Key duty, don't state or imply that you're disinterested. Okay, if you start talking to this unrepresented person and you realize that they think you're kind of on their side when really you're on your client's side, stop. You have a duty under the rule to correct the misunderstanding. The 4 seed in the top half of this quadrant, rule 4.1, truthful statements to others. The rule prohibits material misrepresentations of fact or law. I bring it up because, not because it happens a lot, but just to remind you that omission by silence can violate the rule. The comments make it clear that if you leave something out that leaves what you said appearing to be true when it's not, that's a problem. That is, shout out to Andrew Minitsky and Jennifer Emmons Butler, paltering, the active use of the truth to deceive. For instance, Jennifer Emmons Butler, VBA Director of Communication and Education, and I were at the VBA meeting at the Equinox a couple years ago. We hiked the pond trail. We got back to the meeting, we told everybody that we hiked the pond trail. Did we actually find the pond? No, we didn't find the pond. Everybody thought we did, though. Arguably paltering, arguably violates the rule. What about puffery in negotiations? Comment suggests no, doesn't violate the rule. That's going against number 13, unauthorized practice of law and whether we should license paralegals. Don't get a lot of questions on UPL. It's here because you have a duty to the profession, really, to the system. Not only yourself not to practice where you're not admitted or licensed, but not to allow somebody or assist somebody else to do so either. I think licensing paralegals is arguably a duty that we owe to the profession and to the public. I was on the Vermont Commission on the Future of the Legal Profession that Dan Richardson formed a couple years ago. My subcommittee recommended licensing paralegals to do various tasks. Recommendation kind of stalled and went nowhere. It's been resurrected recently in other jurisdictions. The PRB was intended to look at it here starting on Friday. Obviously, current events have changed the PRB's focus for the immediate future, so it's been pushed out, but it's an issue that I think we're going to have to deal with. So that's the top half of this bracket, duties to non-clients. If I had to judge from just this half of the bracket, I think Canada's a pretty strong candidate to advance. I also think it's a weak 1 seed, meaning I think there could be an upset here. A lot of lawyers are never in court, so don't have to worry about it. A lot of lawyers think this will never happen to me, and like, I'd rather move something else on. So I could see it getting upset as a 1 seed. Oh, sleepers in this bracket, I think number 9 is a sleeper, threatening criminal prosecution. I get more calls about that than you think, as well as the, hey, they threatened me with a disciplinary complaint. Let's move on to the bottom part of this quadrant. Let's see what we got here. So duties to non-clients. Hope you're still watching along online. Somebody asked me about what are those beer cans up there? Well, they're there for a reason. Starting over there, when I moved here, the first can of every type of beer consumed in this garage gets put up on a shelf, and they go all around. That's what those are doing there. Again, the bar is always closed during the CLEs I do from out here. Okay, the 6th seed in the bottom half of this bracket, contacting former employees of a represented organization. Duty in Vermont is set out in comment 7 to Rule 4.2, fair game. The 11th seed, the organization as a client. Isn't that interesting? They're playing each other in the first round. Sometimes it happens in real life. The NCAA selection committee gets a little tricky. How is this duties to someone, to non-clients? Because when you represent an organization, the corporation, the university, the 2-person partnership, you represent the organization, not the individuals therein. And if they are confused, you got to be pretty clear with them about who your client is. Government agencies. Number 3, the rat rule, the duty to report another lawyer, duties that you owe to the profession. The rat rule, my good friend Joan Wang, that's what she always called it. May you rest in peace, Joni. The rule in Vermont, Rule 8.3, A, lawyer has a duty to report another, no self-reporting duty in Vermont, another lawyer who the lawyer knows has violated the rules, and it's a violation that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness. Get a lot of calls. Mike, do I have a duty to report? I think I might. I will never say yes or no. I'll say these are the factors you got to consider. Can't say yes or certainly can't say yes without talking to the other lawyer first. I will never say that another lawyer committed a violation without speaking to that lawyer. Where was I? Facing off against number 14, Rule 3.6, trial publicity. The rule prohibits extrajudicial statements that have a I can't remember if it's substantial or significant chance, whatever, of materially prejudicing an adversarial proceeding. Don't get a lot of complaints about this. Kind of surprised that I don't, because I do see some statements in the press where I go, whoa, man, I'm not sure I would have said that. There are exceptions. Pretty much anything said in open court, anything that's filed with the court, you can talk about, describe. But I think it's best to be very, very careful how much you say to the press, particularly in the high-profile cases. But again, don't get a lot of complaints, and I've read a lot in the papers. 7 seed here, civility. How's that a duty to a non-client? I think it's a duty we all owe to each other. We're not very nice to each other. I mentioned it in my video last week, how many lawyers have told me that one of the biggest causes of the stress and anxiety in the profession is how lawyers treat each other, that we're jerks to each other. We can be better. I think we owe that to each other to be more civil. Facing off against number 10, social media. What about your duties to a client's adversary? Can you look at their social media platforms? Can you send them friend requests? Do you owe them duties if your client takes down information that's been posted to social media or asks you, hey, can I scrub that from my Facebook account? Don't get a lot on that yet. I think it's going to start happening. Number 2 seed, wellness. I think we have a duty to others, again, non-clients, all of us, other lawyers, to ensure that they feel comfortable coming forward to get help. We have to destigmatize it. Been talking about this for years. It's so crucially important. If you need help, get it. If you know a lawyer who needs help, help them. That's a duty that we owe to someone who's a non-client. And the 15 seed in this quadrant, ex parte communications, you have a duty to your adversaries not to be speaking to the judge without including the adversary. Also a duty not to contact jurors in an ex parte fashion. Anyway, that's this bracket. I'd say in this section of the bracket, the duty to report is a big one, as is contacting former employees. I think they're headed for a showdown. I see coming out of this bracket, one of those two or the wellness issue. So that's it. And then they would face off against whoever comes out of the top half. Man, I don't know. I'm going to predict, I'll go with the rat rule versus candor to the court as the final in this quadrant to advance to the final four in the overall tournament. I'm going to end this video now, do another one for each of the quadrants, but 4 separate ones so you don't have to sit through the whole thing. This is the first one I've done. I'm only going to be able to post the next 3 if I don't trip over the wire that's between my car, my computer that's sitting on top of my propane grill, and is actually right now sitting in melted snow. So if I don't trip or electrocute myself, I'll be back with some more videos. Thanks all.